welcome to today's immigration tidbit. It's been a lot of years since they passed 245I, okay? In fact, when I think about it, it was the date of qualification is April 30th, 2001. So almost a quarter of a century ago. So it is becoming less and less likely that people either heard of or qualify for 245I, but it is still something that is in play. It is still the law, and it is still something that you need to know of because you might qualify. And when I give consultations, I I always ask questions to determine qualifications under 245I in order to determine if there's a way. I mean, the bottom line is someone who's here out of status can adjust status without having to leave. That's the bottom line. So there are, like I said, less and less primary people that qualify, but there are the derivatives, the dependents, that also fall under 245I, and they are the ones that really are the most to benefit at this time from this particular law. So first of all, what is 245I? Well, it essentially is for people who are eligible to adjust in some manner, meaning that they have some family petition or some employment petition that's current, and minus the fact that they're not here legally and out of status, they're still able to adjust. They basically pay $1,000 penalty, and they don't have to leave the country for 10 years, don't have to do a waiver, and they're able to adjust in the US. So let me first go over just what the basic requirements are for 245I. So the first things first, a petition, either family-based or employment-based, needed to have been filed before April 30th, 2001, okay? So for example, if you had a sibling petition that was filed all those years ago, and you've been here in the US illegally ever since, and let's just say the visa number is becoming current, like right now, or close to becoming current, minus some other things, you would be able to adjust in the US to get your green card, even after being here all these years illegally, okay? So that's the first thing. So, secondly, you will have had to have been physically present in the United States on December of 2020, okay? And minus that, there aren't any other real specific requirements for eligibility. Now, when I am giving a consultation, I always ask, did you have any petition filed for you? And if so, when? And many times these days, they'll say, well, I had a petition filed a long time ago. And a long time ago, they'll say 2010, 25. And of course, they're out of the ballpark. They can't qualify under 245I, and we have to do something else, okay? So what I said in the beginning about the derivatives or dependents, that's where 245I comes in. So let's say that somebody had a petition filed for them on April 30th, 2001, and they had a kid, and that kid is now grown and wants to get married, but here illegally. But that kid never had any petition filed for them, right? They can fall under 245I because they were the dependent of a primary that filed before the deadline date. So even though the child, who's an adult now, never filed anything, they can adjust status in the US based on employment or family without ever having filed a thing because they're a dependent. So it's very important, at least for me now, to determine if when I'm speaking to somebody and giving a consultation as to whether they are a dependent of a 245I applicant. Because if so, then that stops them from having to do waivers for unlawful presence, to leave the United States, to fear not being able to come back for 10 years. So 245I is still in play and still can be used if you know what you're doing. It would be a shame for someone who qualifies as a dependent for 245I to have to wait all the years outside or go through all the hassle of a waiver when they didn't need to. So you need to inquire and see if you qualify. Okay?